Okay, the topic of this video is, why is it important for an attorney to walk into court with a trial brief? So, let's pick up where I left off. Now your case is going to trial. The defense refuses to acknowledge they did anything wrong and refuses to accept responsibility for what occurred to you. Okay, so what does that mean? It means now you're going to go the distance and your case will go to trial. Why would an attorney walk into court with a trial brief? What is a trial brief first? A trial brief is a report. It's basically a report that helps the judge understand what the legal issues are in this case. Because the attorney knows going into this case that the judge may not be familiar or totally familiar with all the nuances of the various laws that apply in this particular case. So it's the attorney's obligation to go ahead and let the judge know that, you know what, here are the legal issues that are likely to arise in this particular case. And here's the case law to support our position on these various legal issues. So let's say there was an issue about something contained in a medical record that we did not want coming into evidence during the course of trial. Now I have to obtain case law to show to the judge that when and if this issue does arise, whether we want to get this medical record into evidence or the defense wants to get it in, now I have the ability to show the judge, there is case law on this issue which says that you cannot allow this particular information into evidence. And now I can present that to the judge can look at it, do his own legal research, and come to a conclusion about whether or not I'm correct. And it's critically important because it also shows the judge that not only are we prepared, we are fully informed, and we want to inform the judge about what the legal issues are. And this way it gives the judge a leg up on understanding the key issues that are likely to arise during the course of the trial. If we walked into court without having a legal brief, number one, it means likely that we are unprepared. Number two, it also puts the judge at a disadvantage because now we're forcing the judge to do the legal work before we have a chance to give it to him. Now I can simply during trial say, Your Honor, if you look at my legal brief on page 5, you'll see there are 3 cases that talk about this exact issue to support our position. And now he can turn to the defense lawyer and say, Counselor, what do you have to say? And in all likelihood, the defense attorney will not have a legal brief to oppose it. But I should tell you, a good judge is likely going to give the defense lawyer an opportunity to go ahead and do that legal research and tell him to have that information after lunch or later in the day or tomorrow morning. That's a possibility. That can happen. So why do I share this quick information with you as I share this journey on the beach with you? I share it with you because I want you to understand how these cases work, because it helps you better understand the process. It helps you better formulate in your mind the things that you are likely to go through if your case goes all the way to trial. And as we discuss this, I'm sure you have questions in your mind that need to be answered. Well, if your matter did happen in New York and you need answers to your questions, but have not yet started a lawsuit and are thinking about doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.